Good morning, friends. Welcome to our YouTube channel. Today we discuss some important concept. It is for GK and law students for the understanding the concept. Appointment of judges. Under the constitutional setup, the courts in India are accepted to assume much wider and vast responsibility than traditionally invested. For that, the capabilities of judges is extremely crucial factor to be taken into consideration, as only this can lead to an effective and efficient judiciary. The selection of a competent judge is a difficult task. If a person gains entry without conforming the high conforming to the highest standard, then she cannot be expected to deliver the best. Article 124 of the Constitution of India provides that every judge of the Supreme Court is to be appointed by the President after consulting with other judges of the Supreme Court and High Court. In case of appointment of judge other than the Chief Justice of India shall also be consulted. In case of High Court, Article 217 provides that judge of a High Court is to be appointed by the President after the consultation with the Chief Justice of India, the Governor of the state, and in the case of appointment of a judge other than the Chief Justice of High Court. This procedure had worked fairly satisfactorily till 1993, when the Supreme Court interpreted the words after consultation to mean with the concurrence of the Chief Justice of India. After this, the role of the executive at the central and the state levels become marginal, and the decision on the appointment of judges today rests de facto with the judges themselves. The recent stand of between the judiciary and the executive over the appointment of judges of the Supreme Court and the High Court had lead the President to seek the advisory opinion of the Supreme Court. Bracket under the Article 143 Constitution of India. Bracket complete for the appointment of judges. The nine judges bench, which heard the President's reference, held that recommendations made by the Chief Justice of India without complying with the norms and requirements of the consultation process were not binding on the central government. Thus, it widened the consultation process among judges while limiting the role of the Chief Justice of India in the selection process. It is necessary to put an end to the controversy over the present mode of selection of the judges. The method is defective as it is not open to a public scrutiny, lacks accountability and transparency. Appointment of judges by judges themselves possesses challenge to the democratic system. This may lead to the appointment of judges who hold similar ideological or philosophical position. The executive, the legislature, the public, and the judiciary should be given an appropriate level. The system of appointment of judges should be made transparent and subject to the legal scrutiny. Here we discuss about the appointment of judges. Now we discuss the how the judges selected. There is the MPSC conducted preliminary examination for 100 marks, which have the multiple choice question. In that examination, those who are selected for the main examination, there is also 200 marks paper first and paper second. Then there is the 50 mark interview, and after that, if selected, then appointment as judicial magistrate first class will be given. Next term is Bell. The term bail is defined as to set at liberty a person arrested or imprisoned on security being taken for his appearance on a day and at a place named. At a clear form, the above definition bail is granted to a detainee or arrestee. After furnishing the bail required bond, bails are governed by the Code of Criminal Procedure Code, which also classifies the offences as bailable and non-bailable. The grant, refusal, or cancellation of bail is an exercise subject to the judicial discretion, and therefore is bail is granted only after taking into account and carefully considering all relevant factors, including the nature, circumstances, and gravity of the offense, the character of the accused, and whether or not it would be in the interest of justice to release the accused on bail. An important factor that weighed where if the accused after his release is likely to influence the outcome of the case in any manner. Going by the spirit of the Indian Constitution, the denial of the bail is a denial of personal liberty, and therefore the case of bail in non-bail offence is considered in light of Article 21, and the exception to the Article 22 of the Constitution provides for the protection against arrest and detention in certain cases, eviscerating the rights of the arrestee before the bail is granted. The court is required to consider whether, if bail is granted, the accused is likely to come present in the court to face the trial and does not meddle with the evidence or the witnesses. Every accused is presumed to be innocent until proven guilty, and so bail must be not be ordinarily denied unless doing so in somehow likely to hurt the cause of justice. A mere allegation does not make one guilty, which means that an accused is as much entitled to his right to protection of life and personal liberty as only after citizen of India. The grant of bail is the rule and denial is exception. Here we discuss about the bail. Here, here also grant last sentence you remember the grant of bail is rule and denial and exception. There is the bailable and non-bailable offences in IPC. In bailable offence, accused can get bail. In non-bailable offence, accused can be get bail. It is the depend on the circumstances and situation of the case. Bailable offence as the right accused can get a bail, but non-bailable offence it is depend on the mm, facts of the case about the facts of the cases, and it is the discretion of the court and merits of the case. If merits is the that accused non accused can get a bail. We see in many cases there is non-bailable cases accused can get a bail. We discuss about a next concept is child abuse. The talk of children pushes our protective instincts to the extremes when we think of protecting kids. We generally imagine helpless young ones looking up to the adults of protection and justice, and since sexual violence against children is certainly a huge concern for many society for any society, we tend to go into an overdrive the moment the issue of the protecting children against molestation crops up. In our zeal to protect children, we often disregard that sometimes in our efforts to protect them, we might put some of the innocent children in danger, because children also includes young teenagers. A female child must be protected by all means, but that should not translate into making male children more vulnerable to to undeserved prosecution and punishment. In considering age of consent from 16 to 18, the legislature seems to have disregarded the clear distinction between consensual sex and violent rape to the extremely disadvantage of unsuspecting young teenager. What needs to be understood is that it is not the severity of punishment that deters the criminal, it is the certainty of it that does. Moreover, we must further understand that the relaxing standard of proof or meddling with the doctoring of presumption of innocence is extremely dangerous and can land a lot of innocent people in prison for all kinds of reasons other than guilt. It is a time to train cautiously so that we do not do more harm than good. Our noble intention notwithstanding. In India, particularly in Maharashtra, various organizations work for the children डेव्हलपमेंट देर आर व्हेरियस प्रॉब्लेम ऑफ द चिल्ड्रन. आपल्या महाराष्ट्रामध्ये मुलांच्यामध्ये लहान मुलांच्यामध्ये खूप समस्या आहेत. त्या समस्यामध्ये कुपोषित बालकांपासून ते लैंगिक शोषण इत्यापर्यंत समस्या आहे. आणि आपल्याला जेवढी जनजागृती कायद्याविषयी व्हावी तेवढी कायद्याविषयी झाले. काही इंटेरियर भागामध्ये मी साधारणतः गडचिरोली, भंडारा फॉर एक्झाम्पल, वेअर आय व्हिजिटेड देअर, आय सीन देअर नो कम्युनिकेशन, any communications road or other things there. त्याला पाय वाटत जंगलातून चालत खूप अंतरावर जावं लागतं. त्यावेळेला तिथं त्यांच्या गावात पोचता येतो. गावामध्ये अंगणवाडी वगैरे काही नसतं. गाव छोटं असतं. काही काही वेळेला 50 घरांचं सुद्धा गाव असतं गावामध्ये. पण एक तुम्हाला सांगावंसं वाटतंय की जेव्हा गडचिरोलीमध्ये मी हे सर्व बघितलं, आदिवासी भागांचा अभ्यास केला, त्यावेळेला मला असं जाणवलं की त्या परिस्थितीमध्ये ते लोक खूप छानपणे जीवन जगत आहेत. त्यांच्या समस्या ह्या वेगळ्याच आहेत आणि त्या समस्या घेऊन ते जीवन ते त्यांची जंगल ही संपत्ती मानून त्या जंगलामध्ये व्यवस्थित राहत आहे आणि सरकार त्यांच्या समस्या सोडवण्यासाठी प्रयत्न करत आहे. आणि आत्ता आम्ही आमच्या आरोग्यासाठी बाबा आमटे म्हणा, या पुन्हा सोशल वर्कर अभय बंग साहेब हे त्या भागामध्ये काम करत आहे. डॉक्टर अभय बंग साहेबांनी तर त्या भागामध्ये खूप छानपणे आदिवासी लोकांना वैद्यकीय ट्रीटमेंट देण्यात आले. तिथे माझ्या पाहण्यात आलं की साधारणपणे अमेरिकेमधून डॉक्टर तिथे येतात आणि त्या आदिवासी लोकांची ट्रीटमेंट करतात. आणि एक सामाजिक कार्यकर्ता म्हणून अभय बंग साहेबांनी खूप छान काम केलेलं आहे. ते बघण्यासारखं काम. आपण आता नेक्स्ट कॉन्सेप्टकडे जाऊया. Central Vigilance Commission has been constituted under the Central Vigilance Commission Act 2003. The commission is empowered to inquire into the offences committed under the Prevention of Corruption Act 1988 by the public servant of the central government corporations, central government companies, societies, and local authorities owned and controlled by the central government. The commission is headed by the Central Vigilance Commissioner as a chairman, and a maximum of 2 other vigilance commissioners are appointed by the President of India. According to the provision of the Act, the Central Bureau of Investigation (CBI), before conducting an inquiry into an offence committed by the officers of the rank of Joint Secretary or above in any government department or any public sector undertaking, has to take prior approval of the central government and has to seek the response of the central government. The Supreme Court has at a few occasions shown its displeasure towards the provisions. Here is a now important concept: citizenship. Article 5 and 11 of the Constitution of India deals with the citizenship. Article 5 deals with the citizenship at the commencement of the Constitution and declares that every person domiciled in the territory of India at the commencement of the Constitution, that is 26 January 1950, and who was born in the territory of India, or either of whose parents was born in territory of India, or who has been ordinary residents in the territory of India for 5 years, or more immediately preceding the commencement of the Constitution, shall be the citizen of India. Under the Constitution, there is only one domicile, that is domicile of the country, and there is no separate domicile for a state. To be domiciled in India, one must have permanent home in the country. म्हणजे Part second also deals with rights of citizen of certain persons who have migrated to India from Pakistan, right of citizenship of certain migrants to Pakistan, right of citizenship of certain person of Indian origin residing outside India. Person voluntarily acquiring citizenship of foreign state are not citizen and in continuance of the rights of citizenship. This part gives the Parliament of India the power to regulate the right of citizenship by law. The Citizenship Act 1955 regulates the provision for citizenship. The central government has exclusive jurisdiction to determine the question of citizenship of a person. The court has no power in this regard. In December 2003, the central government amended the Citizenship Act. This amendment provided for dual citizenship of PIO, people of Indian origin, in 16 specified countries. The names of the 16 specified are given in the fourth schedule to the Citizenship Act 1955. It is also important to note that the state government has no jurisdiction to determine the citizenship of a person unless the function is delegated to the central government. The Citizenship Act also provides for the acquisition and termination of citizenship. Civil and Criminal Court. नेक्स्ट कॉन्सेप्ट सिव्हिल अँड क्रिमिनल कोड म्हणजे दिवाणी आणि फौजदारी न्यायालय. The distinction between civil adjudication, criminal prosecution is that the latter relates to offences committed against the state, while the former deals with disputes between the individual parties. In criminal prosecution or proceeding, one of the parties is necessarily the state, while in a civil dispute, the state may or may not be a party, though the judiciary authority is either the judicial arm of the state or is authorized to act that way by the state itself. In case of a crime, the criminal justice system springs up on its own, while in case of civil disputes, the adjudicatory process has to be set in motion by aggrieved party. Civil courts have power to have person arrested, to be produced before them, or for other person related to any civil proceeding pending before them, but cannot award punishment by way of imprisonment. A criminal court, however, has the power not only to impose penal imprisonment but also award monetary compensation. In other words, a criminal court, while disposing a criminal case, may also act as civil court, but civil court cannot clothe itself with the power of criminal court when it comes to awarding the penal imprisonment. थोडक्यात इथं डिस्कस केलेलं आहे दिवाणी आणि फौजदारी न्यायालय म्हणजे सिव्हिल अँड क्रिमिनल कोर्ट. क्रिमिनल कोर्टामध्ये ऑफेन्स, पनिशमेंट, FIR, इन्व्हेस्टिगेशन, इन्क्वायरी, ट्रायल तसं याबद्दल असतात. आणि साधारणपणे इंडियन पिनल कोडनुसार इंडियन IPC, पोक्सो, संपेशलाइज पोटा, प्रिव्हेन्शन ऑफ टेररिस्ट ॲक्ट याद्वारे कॉग्निजेबल, नॉन कॉग्निजेबल अपराध घडला तर ती केस पोलिसांकडे जाते. पोलीस त्याचं इन्व्हेस्टिगेशन करतात. नंतर ती फौजदारी म्हणजे क्रिमिनल कोर्टामध्ये येते. दिवाना दावामध्ये प्रॉपर्टीबद्दल वाद, एखाद्याने पैसे कॉन्ट्रॅक्ट असेल त्याबद्दल असेल, ते पुन्हा काहीतरी जमिनीचा वाद त्याबद्दल असेल. याच्यामध्ये सिव्हिल कोर्टामध्ये प्लेंटिफ, डिफेंडंट, कॉज ऑफ ॲक्शन, कॉज ऑफ ॲक्शन महत्त्वाचं आहे. त्याशिवाय प्लेन दाखल करा नाही. तुमच्याकडे जर कॉज ऑफ ॲक्शनच नसेल तर प्लेन दाखल करू नये. पुन्हा सिव्हिल कोर्टामध्ये मॅटर चालता इश्यू फ्रेम केले जातात. म्हणजे कोणता इश्यू आहे. आणि क्रिमिनल कोर्टामध्ये चार्ज फ्रेम केला जातो. सिव्हिल कोर्टामध्ये इश्यूज नंतर त्यांचा एव्हिडन्स घेतला जातो. हे असं सिव्हिल आणि साधारणपणे क्रिमिनल कोर्टामध्ये फरक आहे. नेक्स्ट कॉन्सेप्ट सिव्हिल प्रोसिजर कोड. The law not only lays down the fine distinction between permissible and prohibited, but also prescribes the process for compensation or punishment or both in case the line of distinction is breached. This is to make sure that the process adopted to administer justice casts ample light on all aspects of the case and gives sufficient opportunity to both the parties to place their respective position before the adjudicating authority. The procedure law, in other words, deals with the machinery to be used to enforce the law. The Code of Civil Procedure (CPC) and the Code of Criminal Procedure state the procedure to be adopted in civil and criminal cases respectively. The civil procedure covers the ways to enforce the civil rights and duties. The Civil Procedure Code 1908 deals with the procedure to be followed by the civil courts, but administrative aspects are taken care by the rules made by various high courts, both for themselves and for the courts subordinate to them. The Civil Procedure Code is a uniform code of civil procedure code enacted in the year 19. 1 minute. The Civil Procedure Code is a uniform code of civil procedure enacted in the year 1900. This code deals with civil cases and civil courts and defines decree as a formal expression of adjudication. So far as regards the code expressing it, conclusively determines the right of the parties with regard to all or any of the matters in controversy in the suit, and may be either preliminary or final. This code also defines a decree holder, foreign court, foreign judgment, government pleader, high court rule judge, judgment debater, legal representative, movable property, and the rule. Civil Procedure Code is procedure law dealing with the types of suit, place of suing, execution of decrees, incidental proceeding, special proceeding, supplement proceeding, reference, review, and revision of cases, provision related to high courts, parties to suit, frame of suit, recognize evidence and pleader, institution of suits, issue and service of summons, pleadings, plaints, written statement, set up and counterclaim production, impounding and return of document, disposal of the suit at the first hearing, summons and the attendance of witness, adjournment of cases, hearing of suits and examination of witness, affidavit, judgment and decree, cause, execution of decree and order, withdrawal, adjustments of suit, appointment of receivers, appeals from original decrees and appellate decrees and orders. This code also provides for the appeals to Supreme Court. The civil procedure the criminal procedure code and the civil procedure code both are procedure law. The Court Procedure Code deals with the criminal matters and criminal courts, whereas the Civil Procedure Code deals with the Civil Procedure Code and civil. Civil Procedure Code हा कायदा कसे केस कोर्टामध्ये कशी चालते याच्यावर आधारित असा कायदा आहे. जेव्हा दोन्ही व्यक्तीमध्ये वाद निर्माण होतो म्हणजे कोर्स ऑफ ॲक्शन निर्माण होतो त्यावेळेला तो दावा दाखवू शकतो. आता जो दावा दाखवू शकतो म्हणजे सूट फाईल करू शकतो त्याला प्लेंटिफ म्हणजे वादी असे म्हणले जाते. ज्याच्या विरोधात दावा दाखल केला जातो त्याला प्रतिवादी असे म्हणले जाते. म्हणजे इंग्लिशमध्ये प्लेंटिफ, डिफेंडंट, मराठीमध्ये वादी, प्रतिवादी. आता दावा दाखल केल्यानंतर त्या दाव्याची व्हॅल्युएशन म्हणजे किंमत केली जाते, व्हॅल्युएशन केलं जातं. त्यानुसार त्या व्हॅल्युएशनची रक्कम ही सरकार जमा कोर्टाच्या द्वारे केली जाते. ती रक्कम जमा केल्यानंतर दावा दाखल करण्यात यायला जातो. दावा दाखल करण्याची पुन्हा स्टेज अशी येते की त्याचं ज्युरिडिक्शन पाहिलं जातं. म्हणजे दावा कोणत्या कोर्टामध्ये दाखल केला पाहिजे हे कशावरून ठरवायचं. हा दावा दाखल करण्यासाठी साधारणपणे 3 ते 4 कारणं असतात. त्यातलं एक म्हणजे प्लेंटिफचा ॲड्रेस, प्लेंटिफ जिथं राहतो तिथं, डिपेंडंटचा ॲड्रेस, कॉज ऑफ ॲक्शन, इथं दावा दाखल करू शकतो. समजा जर तुम्ही वादी आणि प्रतिवादी यांच्यामध्ये करार मुंबई येथे चाललेला आहे. वादी हा मुंबईला राहतो पण प्रतिवादी हा समजा सातारा येथे राहतो. तर दावा कुठं दाखल करायचा, हे सातारामध्ये दाखल करायचा का मुंबईमध्ये दाखल करायचा हे वादी डिसाईड करतो दावा कुठे दाखल. पण दावा का दाखल करताना म्हणजे सर्वात स्मॉलेस्ट कोर्टामध्ये दावा दाखल करावा. डायरेक्ट दावा हायकोर्टामध्ये दाखल करून घेतला जात नाही. ज्युडिशियल मॅजिस्ट्रेट फर्स्ट क्लास मध्ये सिव्हिल सिव्हिल जज ज्युनियर डिव्हिजनमध्ये दावा दाखल केला जातो. यामध्ये सुद्धा पिक्युनरी ज्युरिडिक्शन, टेरिटरी ज्युरिडिक्शन हा इतर भाग आपण नंतर लेक्चरमध्ये डिटेल पाहणार आहोत. कॉन्ट्रॅक्ट म्हणजे करार. हा प्रत्येकाच्या जीवनामध्ये म्हणजे समाजामध्ये कॉन्ट्रॅक्टची जरूरत असते. कोणता ना कोणता करार नेहमी होत असतो. Social relationships are based on mutual understanding and agreements and commercial interaction. More so, for it is, after all, about the confluence of commercial interests. This is where the law of contract comes to ensure fair play and dispute redressal. Concepts like property sale, purchase, ownership or title and the price are basically economic in nature and necessities commercial law. The law regulates the contract facilitates trade transaction within itself. In case of trading in promises for future delivery, traders can reduce uncertainty about the future. This requires adjudicate legal safeguards so that both the parties to the contract are secure and may plan their commercial move accordingly. Indian Contract Act was enacted in 1872. The act provides for the enforceability of the contract, capacity of parties, consideration of contract by minors, free consent, bailment, pleas, agency agreement, undue influence, mistake of fact, law, misrepresentation, indemnity, guarantee. The law of contract is completely innocent. The important aspect of law of contract is that it deals only immovable property and leaves movable property outside its ambit. The law of contract provides the remedy in case of a breach of contract. कॉन्ट्रॅक्ट म्हणजे काय, कॉन्ट्रॅक्ट करून करू शकतं याच्याविषयी याच्यामध्ये डिस्कस केलेलं आहे. कॉन्ट्रॅक्ट कोणीही करू शकतं. नाही. कॉन्ट्रॅक्ट कोणीही करू शकत नाही. कॉन्ट्रॅक्ट करणारी व्यक्ती सुज्ञ असली पाहिजे. म्हणजे ती 18 वर्षापेक्षा जास्त, आणि जर गार्डियन असते त्याला असेल, पालक पालक असतील, तर ते 21 वर्षापेक्षा जास्त असावा. तो तेव्हा तो कॉन्ट्रॅक्ट असावा. कॉन्ट्रॅक्ट करताना सुद्धा काही अटी शर्ती आहेत. तो सुज्ञ असला पाहिजे. पुन्हा ते जबरदस्तीनं कॉन्टॅक्ट करता आला नाही, किंवा धाक दाखवून त्याच्याकडनं कॉन्टॅक्ट करून घेता येत नाही. जर त्याला धमकावून, धाक दाखवून जर कॉन्ट्रॅक्ट केलं असेल, तर ते कॉन्ट्रॅक्ट रद्द, व्हॉइड म्हणून मानलं जातं. किंवा एखाद्याला फसवून एखादा करार करण्यात आला, तर ते करार हा रद्द केला जाऊ. याविषयी आपण डिटेल कॉन्ट्रॅक्ट या चॅप्टरमध्ये पाहू. Biggest problem of the Indian woman: cruelty against women. Cruelty against women has been age-old phenomena where women have been subjected to brutality and inexplicable exploitation for one reason and or the other. In the male-dominated world, she has been treated not better than a commodity, a mere puppet in the hands of her so-called protector, be in the form of father, brother, and subsequently her husband. For the rest of her life, her position has been reduced next to nothing, to the extent that she cannot take a decision of her own. By virtue of this pathetic plight, she has been enduring cruelty maintained out with her at the hands of her husband and his relatives. In the wake of such widespread violation and cruelty inflicted upon women, Section 489A has been inserted in the IPC, which specifically deals with cruelty towards a woman by her husband and or his relative. The provision brought some relief to women whose life has become miserable because of torture and violence perpetrated against her by her husband or his relatives. And at the same time, the imposed provision pays a tribute to those who chose to commit suicide after being frustrated by persistent harassment, causing them to suffer from mental as well as physical agony. It was for the first time that the imposed provision made it punishable for a husband or his relatives to the subject to women to cruelty. The law explicitly recognized mental cruelty and mental hate as well. Cruelty was defined as any conduct likely to cause grave injury and danger to life, limb, the mental harassment, physical health of woman, or to drive her to commit suicide, harassment, or coercion of a woman or her relative. To fulfill the demands of money or property was included within the definition of a grad. आता विचार करून सांगायचं म्हणजे तुम्हाला, आत्ता महिलांची परिस्थिती बरी आहे. मी म्हणतोय बरी आहे, चांगली नाही. महिला पुरुषांच्या बरोबरीने काम करतात, तरी त्यांची काही ठिकाणी हॅरॅसमेंट होत. अशा केसेस आपण पाहिल्या आहेत. किंवा विशाखाचं जजमेंट या संदर्भात खूप काही बोलून जातं. माझी अशी विनंती आहे, ज्यांना ह्या टॉपिकमध्ये इंटरेस्ट आहे त्यांनी विशाखाचं सुप्रीम कोर्टाचं जजमेंट नक्की वाचावं. पूर्वीच्या काळी महिलांना घरातून बाहेरच जायला सोडलं जायचं नाही. आपल्या महाराष्ट्रामध्ये महात्मा फुले आणि सावित्रीबाई फुले यांनी महिलांसाठी शाळा सुरू केली. पहिली शाळा बुधवार पेठ पुण्यामध्ये सुरू केली आणि पहिल्या महिला शिक्षिका ह्या सावित्रीबाई फुले आहेत. त्यांच्यामुळे थोडं करत समाज पुढे आला. आता आता महिला मुली पुर पुरुषांच्या खांद्याला खांदा लावून काम करतात. जर आपण पाहिले तर मुंबईच्या ठिकाणी सारख्या ठिकाणी महिला ह्या खूप लांबून विरार इकडं येऊन येऊन आपलं व्हीटी या ठिकाणी ऑफिसेसमध्ये काम करतात आणि पुन्हा त्या जातात. हे काम करत असताना त्यांना दोन्ही जबाबदारी एक घरातलं सुद्धा बघून बाहेरचं ऑफिसचं सुद्धा काम करायचं असतं. दुसरा गोष्ट म्हणजे काही अशा गोष्टी असतात की त्या महिला कधी पुढवून स्वतःहून तक्रारही करत नाहीत. महिला गपचूप सोशिकतेने शोषत असतात. दुस काही ऑर्गनायझेशन ह्या वुमेन्स अँड चाइल्ड रिलेटेड NGOज म्हणून ओळखल्या जातात. त्यामध्ये त्या ऑर्गनायझेशनची या महिलांना खूप मदत होण्यासारखी आहे. ज्या महिलांना शक्य असेल तर त्यांनी ऑर्गनायझेशनची मदत करा. आता ह्या ऑर्गनायझेशन आम्हाला मिळणार कशा? तुम्ही आता सध्या तुम्ही इंटरनेट तुमच्याकडे आहे. तुम्ही वुमेन्स ऑर्गनायझेशन म्हणून इंटरनेटवर सर्च मारलं तर इथं फॅमिली प्लॅनिंग असोसिएशन, इतर ऑर्गनायझेशन, मजलिस ऑर्गनायझेशन, या अशा ऑर्गनायझेशनची नावे, फोन नंबर. पुन्हा तुम्हाला एकदमच हॅरॅसमेंट जास्त होत असेल, त्या ऑर्गनायझेशनपेक्षा पोलिसांकडे जाणं योग्य वाटत असेल तर पोलिसांचा नंबर असतो महिला मदत केंद्र म्हणून. त्या नंबरवर तुम्ही फोन करून पोलिसांची सुद्धा मदत घेऊ शकता. पण साधारणपणे महिला ह्या खूप शोषिक असतात आणि सहनशील असतात. तर आता आपण दुसरा पॉईंट डिस्कस करणार आहोत, फ्री लीगल एड. There is no justice unless there is a sure informity about it. It is not something that would be allowed to be available to those who could parade an army of expensive lawyers. It has to be available to all, and the richest and influenced should be playing any part kept from playing any part in the final outcome of the case. However, in the country like ours, where the poor are neither aware of their rights nor have money to hire lawyers to tell their side of the story to the court, justice ends up becoming a rich man's indulgence. The objective being free legal services for the poor is to ensure equal and uniform justice. The Legal Service Authorities Act 1987 and the relevant constitutional provision form the legal core for free legal services to the poor. Social justice is one of our constitutional objectives, and to secure it for the poor, it is important that the efforts are not just confined to the exemption of the court fees or process fee or the legal assistance in court. Indian democracy is based on the principle of equality, justice, human dignity, and fraternity, and a society that fosters social and economic equality on one way or the other is undemocratic. Without an appropriate system of administration of uniform justice, democracy has no real meaning. That is no way that the rule of law can actually operate without effective free legal aid to poor. गरीब समाजाला न्यायापासून वंचित ठेवता येणार नाही. त्यांना कायदेशीर सहाय्य हे फ्री लीगल सर्व्हिस अथॉरिटी कायदेशीर सहाय्य हे लीगल सर्व्हिस अथॉरिटी ॲक्टनुसार 1987 ॲक्टनुसार त्यांना दिले जाते आणि ती काळाची गरज आहे. जर गरीब लोकांना, गरीब समाजाला जर कायदेशीर सल्ला किंवा कायदेशीर बाबी यांविषयी जर माहिती दिली, त्यांना जर पोचवण्यात आली नसेल तर त्या कायद्याची पूर्ण संकल्पनाच येईल. म्हणजे एव्हरीबडी शुड बी ट्रीट ॲज ए इक्वल. म्हणजे कायद्यासमोर सर्व व्यक्ती समान आहेत. We are discussing next point is the human right. Human rights are those rights without which life, human dignity has no meaning, which explains why these rights are considered to be the very basic legal rights internationally. These rights relate to life, liberty, equality, dignity of the individual. Our Constitution guarantees these rights, and the Supreme Court has ruled that wherever the Constitution is silent and the legislature has not made a law, those international covenants to which India is a signatory may be enforced, though the courts so far as they are consistent with the law of the land. These treaties and covenants may also be taken help of in statutory construction. The framers of the Constitution of India incorporated all basic human rights as fundamental rights and made special provision to ensure their enforcement under the Article 226 and Article 32. The Constitution of India was drafted after Universal Declaration of Human Rights of the United Nations on December 10, 1948, and therefore some idea were borrowed right from the declaration itself. Indian Parliament enacted the Protection of Human Rights Act in 1993 to provide for the constitution of the National Human Rights Commission, State Human Rights Commission, and the Human Rights Courts for the protection of human rights. Human Rights Commission receives the complaint from the victim or any person on his behalf and inquiries into the violation of human rights and also into the negligence of the authorities in the preventing such violation. ह्युमन राईट मानवी हक्क आयोग या मानवी हक्क आयोग मानवांचे म्हणजे ह्युमन राईट असतात त्याबाबत आपल्या एक जगामध्येच ऑर्गनायझेशन काम करत आहे. युनिव्हर्सल डिक्लेरेशन ऑफ ह्युमन राईट पूर्ण जगामध्ये ह्युमन राईट विषयी काम झालेलं आहे. काही एन जी ओ आपल्या मुंबईमध्ये दिल्लीमध्ये सुद्धा ह्युमन राईट विषयी काम करतात. आता आता दुसरा पुढचा आपण पॉईंट पाहणार आहोत. इंटरनॅशनल कोर्ट ऑफ जस्टिस. The International Court of Justice is successor of the Permanent Court of International Justice and one of the principal organs of the United Nations organization. It is also known as the World Court. Its head office is located in the Hague, Netherlands. It is head office located in Hague and Netherlands. It was established in 1945 by the UN Charter. The Statute of the International Court of Justice is the main constitutional document instituting and regulating the court. The ICJ is composed of 15 judges elected for 9 years by the United Nations General Assembly and the UN Secretary Council from a list of persons nominated by the nations groups in the Permanent Court of Arbitration. All the members of the United Nations automatically become parties to the court's statute. Even non-UN members may also become a parties to the court statute. However, being a party to the statute does not automatically confer the jurisdiction of the court over dispute involving the parties. Jurisdiction of the court basically involves two types of issues: contentions issues and advisory opinions. Jurisdiction often a crucial question for the court in contentious cases. The key principle is that the ICJ has jurisdiction only on the basis of consent. An advisory opinion is a function of the court, open only specified United Nations bodies agency. The court's advisory opinions are only consultative in nature, but even then it is influenced and widely respected. While deciding the cases, the court applies international law like international conventions, international customs, the general principle of law recognized by civilized nation in the precedent and also teaching of the jurist. Now we discuss about the International Labour Organization. International Labour Organization, the ILO, is international organization responsible for drawing up a overseeing international labor standard. Was sorry, 1 minute. ILO is the international organization responsible for drawing up and overseeing international labor standards. The ILO was created in 1919, 1919, as a part of Treaty of Versailles. Treaty of Versailles that ended World War First. That ended World War First to reflect the belief that the universal and lasting peace can be accomplished only if it is based on social justice. The Constitution was drafted between January and April 1919 1919 by the Labour Commission set up by the Peace Conference, which first meets in Paris and then in Versailles. The commission chaired by Gompers Samuel Gompers, head of the American Federation of Labor in the United States, was composed of representatives from 9 countries: Belgium, Cuba, Yugoslavia, France, Italy, Japan, the the United Kingdom, and the United States. It it resulted in tri-party organization, the only one of its kind, bringing together representatives of government, employee, and workers in the executive bond. The the ILO has four strategic objectives. First, promote and realize standard and fundamental principle and rights at the work. Second, create greater opportunity for women and men to decent employment and income. Third, enhance the coverage and effectiveness of a social protection of all. Strengthen tripartism and social dialogue. This is the information about the ILO. Important concept. Judiciary. Listen carefully. Law has a no meaning without the adequate enforcement. That is why our constitution has put in place an elaborate judicial system with the Supreme Court at the affects. The framers of the constitution were aware that political power has to be effectively checked so that it is used only for the prescribed purpose and only in the prescribed manner. If Parliament enacts a law that runs against the word or spirit of the Constitution, Supreme Court exercising the power of judicial review can strike it down and unconstitutional, and arbitrary executive action too can be checked in the like manner by judicial action. The doctrine of basic structure evolved and applied by Supreme Court has ensured that Parliament could not go on amending the Constitution to achieve shallow political gains. In the past 55 years, judiciary has been that wing of the state that has not only constantly performs its own duties but also made the other two wings perform theirs. In India, in India, the body of law constitutes the constitution at the very top and as the source of law. And then there are laws enacted by parliament and state legislature. Judicial decisions of the higher courts catalyze the law and sometimes act as a precedence if the area is unoccupied for lack of legislation. Supreme Court. It consists of the Chief Justice and 30 other judges. They are appointed by the President in consultation with Chief Justice. Independence of judges. If a society based on a rule of law, social justice is to be achieved, it is important that justice is administered without fear or favor. Our constitution therefore seeks to preserve and promote the independence of judges through various means. Salaries and conditions of service for the judges are fixed and cannot be varied to the disadvantage of the judge during the tenure in the office. Removal of judges. In order to ensure that the fear of removal does make our judges planned, the Constitution provides for an extremely cumbersome process for the removal of a judge under Article 124 bracket 4. Jurisdiction of Supreme Court. The Supreme Court of India exercises three kinds of jurisdiction: original jurisdiction, appellate jurisdiction, advisory jurisdiction. One, original jurisdiction. Supreme Court under its original jurisdiction adjudicates in matters concerning dispute between the center and state, and also between all among individual states. A citizen might also approach the apex court directly under Article 32 if any of the fundamental rights is violated. Second, appellate jurisdiction. Under its appellate jurisdiction, the Supreme Court sits as a court of final appeal in all matters constitutional, civil, criminal, and others. Advisory jurisdiction. Under the advisory jurisdiction, Article 143, the President can refer to any question of law or fact of public importance to the Supreme Court for its advisory opinion thereon. Article 129 of the Constitution declares that the Supreme Court is a court of record, which means that its a decision has a precedent value. In other words, the decision of the Supreme Court not only settle a legal matter but also sets a precedent to be followed by all courts throughout the country. The Supreme Court has the power to punish for its own contempt. Now, today we are here. Stop our lecture. This is the only the we started YouTube channel just now. Our main aim is that our main aim that की आम्ही सध्या काही मित्र माझी पत्नी मित्र मिळून यूट्यूब चॅनल सुरू केलं. ॲडव्होकेट माधुरी संदीप लावण यांची ही संकल्पना आहे. याच्यामध्ये माझे मित्र श्री मिस्टर विश्वजित लाड, मिस्टर महेश देवलेकर, ॲडव्होकेट नित्यानंद शेट्टी, ॲडव्होकेट परमार सर, ॲडव्होकेट धनंजय देशमुख हे याबाबत मार्गदर्शन करत आहेत. या चॅनेलद्वारे आम्ही सर्व विद्यार्थी म्हणजे जे LLBच्या परीक्षेसाठी बसलेले आहेत आणि जे JMFCची तयारी करत आहे त्यांच्यासाठी मार्गदर्शनपर व्याख्यान लेक्चर सिरीज सुरू करणार आहे. आमचा कमिटी म्हणजे आमच्या कमिटीचे सदस्य महेश देवळेकर सर, नित्यानंद शेट्टी, ॲडव्होकेट सौ माधुरी लावण या सर्व मिळून या मटेरियलवर आणि लेक्चर्सवर काम करत आहे. मी तुम्हाला विनंती करत आहे की तुम्ही आमचे चॅनल सबस्क्राईब करा आणि आमचे चॅनल पाहत राहा. आणि तुम्हाला जर काही माहिती किंवा पाठवायची असेल किंवा माहिती पाहिजे असेल तरी तुम्ही या चॅनलवर जो Gmail ID दिलेला आहे त्या आय डीवर तुम्ही माहिती पाठवू शकता. धन्यवाद.